Good morning, everyone. Welcome to this webinar on international employment in the post-COVID and post-Brexit era, how to cross borders safely. My name is Kato, and I will be hosting this webinar together with my colleague, Philippe Dereau. On the right-hand side of your display, you can find the presentation that you can download. During the webinar, we will also launch some poll questions to test your knowledge on what we are explaining. And should you have any questions, please feel free to put those in the chat function. We will address these questions during the webinar, or if we don't have sufficient time, we will do that after the webinar. On the agenda for today, 3 items, basically. First of all, post-COVID, where will your employees be socially insured and what are the other consequences if you allow continued telework? The second topic will be on Brexit, post-Brexit. What is the impact of Brexit and will your employees need a permission to work on Belgian or British territory? And then finally, to which extent will the new Posting Directive impact future secondments from and to Belgium? So let's start with the first topic, post-COVID. As you know, telework has become mandatory during the pandemic in many countries, but also in Belgium. And it was first introduced on the 18th of March 2020 as a measure to combat the spread of the virus. It has remained mandatory in some different forms. Over the summer, it was highly recommended, then it became mandatory again, and it still is today, at least until the end of June. But it is expected that it might be a recommended way of working in the future. And what is particularly important in this context is that many employees actually ask to continue to telework after the pandemic. A lot of employers have noticed that work is being done. It's not so that employees are working less, and more often than not, employees like that they have the opportunity to work at least some days per week from home to make sure that they can balance their work with their private life. So it is a question that many of our clients are faced with. And then obviously the question that is asked to us is how to deal with that, and does this have an impact in terms of social security? As you know, within the European Union, social security is regulated in the regulation of 2004, where mainly the basic principle is that in situations of cross-border employment, employees are socially insured in the country where they work. There are 2 exceptions to that principle, and the first one is the secondment. So basically, that's an employee going abroad to work on a temporary project for a certain period of time, and then returning to the home country afterwards. The second exception is split employment or simultaneous employment, where an employee will be working in different member states without necessarily being seconded to only one, where they will be working 100% of their time. In those exceptions, there is, let's say, an alternative to the principle, because obviously if you are temporarily posted to another country, that would mean if you apply the main principle of you're being socially insured where you work, that you would switch social security systems, which is obviously not desirable if you only go abroad for a short period of time. For split employment, different set of rules apply. The main rule there is that employees are socially insured in their home state if they work at least 25% of their time there. And both of those exceptions are very relevant in relation to the pandemic, because employees who were usually working in a specific country and were living in another country switched their employment, their state of employment, and so should have switched their social security scheme at the same time during the pandemic. If you are working full-time on Belgian territory, that would mean that you would have to be socially insured in Belgium. That is, of course, not really desirable in the situations that we face. It was already quite turbulent and difficult to begin with. So why switch social security systems? Because of the mandatory government measures that were being imposed. So that's why the Belgian Social Security Administration decided that the periods of telework in Belgium, due to the COVID-19 pandemic and the government measures that were put in place, were neutralized during that period. And those measures are in place since the 13th of March 2020 and continue to apply until the 30th of June of 2021. And basically, there are 2 conditions. So first of all, the Social Security Administration states that if the changed work pattern is only due to the government measures, then you can indeed remain socially insured in the country where you were socially insured, on the second condition that the situation returns to normal as soon as the pandemic is over. And it's specifically that condition that we want to highlight today, because obviously that means that if you have employees who have been working abroad, are now working in Belgium because of the pandemic and the government measures, but are liking this way of working and asking the company if they continue to telework from Belgium, then obviously you might not meet that second condition if you continue to telework after the pandemic, because you did not return to normal. So the clear to do here would be to define what you want to do in the future. Will you continue to allow telework? How will you do that, and communicate on that with the employees? A specific example, we've had a case where an employee was actually in a split scenario and working 25% of his time in Belgium. The Social Security Administration did not agree and stated that the 25% was only linked to the COVID pandemic. And there we actually had to argue and prove that it was linked to other reasons. In this particular case, it was because the employee returned to Belgium because wanted to spend more time with their family, and we had emails proving that, so it had nothing to do with the COVID pandemic. But you see, they check on that, and they will ask the company to prove that the increased presence on Belgian territory was due to other reasons. Another example could be to say, I have an employee who usually works in the Netherlands, for instance, is living in Belgium and has worked during the pandemic in Belgium. For plenty of reasons, the employee likes working in Belgium, wants to continue to do that after the pandemic as well, has asked the company to do that. And there you might argue that if you continue to do that without interruption, and you just allow the continued telework in Belgium, that the Social Security Administration might argue that actually you've had that intention all along, and this isn't something that has been decided, and so there is no return to normal. So I think it's important to just keep that in mind when organizing telework post-COVID, and potentially even return to normal for a few weeks and then implement a dated, clear policy where you allow the telework, just to ensure that you do not have any errors in payment in Social Security in Belgium. Because after the COVID-19 pandemic, obviously, the temporary measures will no longer apply. And then the main principle that I highlighted at the beginning will apply again. So basically, the country where you're working will be the place where you are socially insured. And I think it's important that companies continue to pay attention to that after the pandemic as well. Then maybe a quick question, a first poll question to test your knowledge on this topic. And it goes as follows. Oh, no, sorry, it's not a question to test your knowledge. It's actually a question to get some information for us. We are actually curious to know whether your company will indeed, A, continue to allow telework at least partially, or will B, require a full-time return to work to the office. I'll leave you the time to answer that question, and then I give the floor to my colleague, Philippe.
So good morning, everybody. I don't know if we will see the answers to the poll question. I think we see them there, but I can't see them. So 94% will continue to allow telework at least partially, but also the remaining 6% get 1 point. There's no good answer on this question, or no wrong answer either. So thank you for attending the seminar. We will immediately continue with the next topic, and that is Brexit, or better, the post-Brexit employment environment in Belgium. Brexit is a very broad topic on which we can easily give a seminar of 1 or 2 hours. We won't do that. We will focus on the highlights, and we will also focus on the situation of UK employees coming to Belgium. Of course, where relevant or possible, we will also say something about the other situations, so from about Belgian employees going to the UK. I will start with the second slide, at least the first line on the second slide, which says that, or the first line of the second slide, which says that essential travel certificate is required for UK employees coming to Belgium. Indeed, as the UK is outside the Schengen area, it must be proven that the trip to Belgium during COVID is essential, and that can be done via such a certificate, which is issued by the Belgian diplomatic post in the UK. However, in practice, also other documents such as a single permit or a work permit are allowed, because that also proves the fact that the trip is essential. Then going back to the first slide, here we see the Brexit timeline, which you might know in the meantime in this form or this layout or another. Brexit is there, officially there, since the 31st of January 2020. However, the consequences of Brexit have been postponed until 2021. Indeed, the UK and the EU signed a withdrawal agreement, and in this withdrawal agreement, the transition period has been installed as if there was no Brexit. So during the transition period, the free movement simply continued. For economic migration, this means that UK employees who were coming to Belgium, or the other way around, Belgian employees who were going to the UK, did not need a work permit or a residence permit. And also for social security, this implied that the EU rules on the coordination of social security continued to apply during 2020. Then on the 1st of January 2021, the withdrawal agreement ended, and consequently also the free movement ended. This means that since the 1st of January 2021, UK employees or UK independent workers are considered as third country nationals, and both for economic migration and the coordination of social security, the Belgian national legislation applies. However, this has somewhat been mitigated in the Trade and Cooperation Agreement. Indeed, contrary to what we expected at the beginning of December, all of a sudden, late December, a deal has been found between the UK and the EU, and the Trade and Cooperation Agreement has been signed, in which some additional measures, provisions that come on top of the national legislation have been agreed. A second mitigating provision is in the withdrawal agreement. This agreement, I explained it in a minute, has terminated on the 31st of December 2020, but still continues to apply for those employees who have exercised or who were exercised their free movement during 2020 and therefore were protected by the withdrawal agreement in 2020. We call that grandfathering rights, and that's the reason why you see a dotted line instead of the full arrow on the slide. In the meantime, also Belgian support measures have been taken. These Belgian support measures are to protect actually or to help Belgian employers who are in trouble because of Brexit. And these measures are, for instance, unemployment allowances, temporary unemployment allowances comparable to the COVID unemployment, working time reduction, and so on. But that is not the topic of today. The slide will become much more clear on the next slides. So let's start with the first Brexit topic, being economic migration. Employees who come to Belgium from the UK to Belgium as from the 1st of January 2021 can be divided in two categories. First category are the UK nationals who are protected by the withdrawal agreement. For these employees, grandfathering rights apply. And then the second category is the UK nationals who are not protected by the withdrawal agreement, and these are considered third country nationals. First category, so the employees protected by the withdrawal agreement, are those UK nationals who have exercised their right to the free movement before the 1st of January 2021. So these are employees who resided in Belgium or who have the status of frontier worker on the 31st of December 2020. And in principle, these employees should have an E-card or an E+ card for the residing employees, and an Annex or an Annex 15 for the frontier workers. What is now the protection? Well, this is quite important. The protection is that these employees simply don't need a residence permit or a work permit to stay and work in Belgium. So these employees continue to be exempted from the work and residence permit obligation. And the status should be formalized. So something must be done, being that the employees or independent workers have to request an M card for those employees who are residing in Belgium, or an N card for those employees who had the status of frontier worker at the town hall of their place of residence, or for frontier workers, the place of principal employment in 2021. So these employees have the time to request the formalization of their protected status until the end of 2021. Two important points of attention. First, be careful with posted workers. Why is that? Well, posted workers do in principle not exercise their right to the free movement. Indeed, these posted workers do in principle come to Belgium in the context of the free movement of services exercised by their employer. And that is why posted workers are in principle not protected by the withdrawal agreement. However, there is a bypass. Indeed, this protected status can also be granted to employees with or to UK residents with sufficient resources. And via that bypass, also several posted employees can benefit from the protected status. So be careful with posted workers. And then the second point of attention is that the M and the N card, so the protected status, is only valid for Belgium. So on the previous slide, we saw that on the 1st of January 2021, free movement has stopped. This means that the protected status cannot be extended to other countries. It only refers to Belgium. That was the first category. The second category, well, that's the employees who are not protected by the withdrawal agreement. Well, for these employees, there is no free movement and they are considered as third country nationals. Hence, the national immigration legislation applies for them, which means that we have to look in the national legislation whether a work permit and or residence permit are required. There are two mitigating measures. On the one hand, a visa-free travel for short stay in Schengen during 90 days in a 180 days period. So that is the well-known visa-free regime, which now also applies to the UK. And the second mitigation measures is in the Trade and Cooperation Agreement. We will come back on that later. Due to these mitigation measures, basically there are two subcategories. The first subcategory are the business travelers. The second subcategory are the default group, the other workers. So the business travelers, let's have a look at residence on the one hand and work on the other hand. Residence, as discussed on the previous slide, business travelers can in principle use the visa-free travel for short stay in Schengen during 90 days and 180 days period. So if this limitation is complied with or respected, no residence permit in Belgium is required. Some points of attention. The 90 days refer to the Schengen area. So it's not only 90 days in Belgium, but in the full Schengen area. These 90 days can also be consumed, for instance, by holidays or other trips outside Belgium. The visa-free travel requires a valid passport for 6 months. Also, the visa-free travel does not exempt from the obligation to file a Limosa declaration. Of course, there are some exceptions in the Belgian legislation. And also, the visa-free travel will not protect you against the ETS rules or ETS regime that will be installed in the course of 2022. So the ETS regime that is the European counterpart of the US ESTA regime, which is actually a pre-travel safety check. So this will also apply to the UK residents who make use of the visa-free travel. That's the residence part, which is mostly solved with this visa-free travel. Then the work part. In the national Belgian legislation, there are already some exemptions for business travelers which allow them to come to Belgium or to work in Belgium without a work permit. These national exemptions can, of course, also be used by UK employees. For instance, attending meetings during a subsequent period of 20 days maximum and 60 days in a full calendar year. That's an exemption that is often used. But on top of these national exemptions, there is also a list of exempted business travel in the Trade and Cooperation Agreement. And there are two upsides. The first one is that the duration of these exempted business travel in the Trade and Cooperation Agreement applies for 90 days in any 6 months period, which is longer than most exemptions in Belgian national legislation. And the second good thing is that the activities that can be performed in Belgium on the basis of this list are larger than the Belgian exemptions. We see this list here. Each of these activities are further explained in the Trade and Cooperation Agreement. That considers, amongst others, meetings and consultations, research and design. We see sales, purchasing, after sales, after lease, translation and interpretation, and so on. So that were the business travelers who are not protected by the withdrawal agreement. And then we have the other workers who are not protected by the withdrawal agreement. Well, as from the 1st of January 2021, they need in principle a work permit or a single permit, depending on the duration of their stay in Belgium. On the right hand of the slide, you don't see a Shutterstock image, but a print screen of the website of the Belgian Social Security authorities. And on the left side, you see single permit. And indeed, since yesterday, there is a single platform to introduce single permit application files. So you don't longer have to check which regional authority is competent. You can simply file this application via this single platform. There's the normal employees. Also posted employees and do in principle require a work permit or a single permit. There was some confusion about this based on one specific clause in the Trade and Cooperation Agreement, but according to the current interpretation, also posted employees need a work or single permit and are not exempted from this obligation. Self-employed workers need a professional card. And then the last bullet is probably the most important bullet, or hints at the most important consequence of Brexit. That is that there are conditions and timing linked to work and single permits, which means that where it was in the past possible for every UK employee or independent worker to come to Belgium and to exercise their right on free movement, and now this is much more difficult. If you need a work permit or a residence permit, you have to see which one you will apply. If you comply with the conditions, for instance, highly skilled workers or leading personnel, there are often remuneration restrictions or remuneration requirements which must be complied with, and so on. So for an entire group of especially lower skilled and lower remunerated employees, it will be much more difficult to employ them in Belgium. That was the economic migration part. Then we have the social security part, which is much shorter and much easier. Also for these or for this topic, there are two categories. The first group or the first category are the UK nationals who are protected by the withdrawal agreement. Also for them, grandfathering rights applies. So the dotted line on the first slide, or the dotted arrow on the first slide. The second category are the UK nationals who are not protected by the withdrawal agreement, and for them the Trade and Cooperation Agreement, more specifically a Social Security Protocol to the Trade and Cooperation Agreement, is important. So the first category, the employees who are protected by the withdrawal agreement, well, these are employees and independent workers who were working in a cross-border employment situation on the 31st of December, and that must be 2020, not 2021. What is now a cross-border employment situation? Well, the nationality of the other country is sufficient. So a UK employee who was, or a UK resident who was working in Belgium for a Belgian employer is already in a cross-border employment situation and is thus protected by the withdrawal agreement. Simply having the employer in another country is not sufficient. And what is now this protection offered by the withdrawal agreement? Well, it is the continued application of the EU regulations on the coordination of social security, as long as the cross-border employment is not interrupted. So if you have, for instance, an employee who is sent to Belgium from the UK for a period of 2 years. After these 2 years, he goes back to the UK. Well, at that time, the cross-border employment will stop, will be interrupted, and the protection under the withdrawal agreement will disappear. Important here is that a change in the cross-border employment situation does not result in an interruption and in an interruption of the cross-border employment. So if someone starts with a secondment and afterwards started working in a multi-state working situation, this is still a cross-border employment situation and the protection under the withdrawal agreement continues. Are there any to-dos? Well, no, except of course requesting the necessary A1 certificate, but that is rather obvious. But there are no additional steps or no additional documents that must be filed to formalize this protected status under the withdrawal agreement. Then the second category is the Social Security Protocol in the Trade and Cooperation Agreement, which applies to those employees and independent workers who have started working in a cross-border employment situation in 2021, or they have started before 2021, but the situation has been interrupted, due to which the protected status under the withdrawal agreement terminates. And what is now this protection? Well, that's also quite important. This protection in the the regime in the Social Security Protocol is almost identical to the coordination rules in the EU regulations. So these are the lex loci laboris, the secondment, the multi-state working that Kato has explained some minutes ago. So for the new employees or the new cross-border employment situations, well, they actually more or less or almost boil down to the same as under the previous European coordination rules. There are some differences. For instance, that the secondment cannot be extended beyond 2 years. Indeed, under the EU regulations, a secondment is in principle possible for maximum 2 years, but there is a possibility to deviate from this rule and to extend the secondment up to maximum 5 years. Well, this possibility, this deviation possibility, does not exist under the Social Security Protocol in the Trade and Cooperation Agreement. And also, for instance, family allowances are not covered. But for the rest, both regimes are almost identical. Then we have a new poll question. And this question is as follows. Do UK employees who are protected by the Withdrawal Agreement have free access to the French labour market on the basis of their M card?
Okay, answers are in and the majority is right. 53% says no, and indeed that is correct. As Philip explained, there is no free movement anymore or entitlement to free movement. So that is the only correct answer to this question. Let's move ahead. So we've discussed the impacts on social security matters if you continue to telework after the pandemic. We've discussed Brexit, and now we're actually going to make a switch to employment law, because you may have heard there are some changes in that field as well, because there is a new posting directive, and we would like to address the impact of that new posting directive in the last part of this webinar. So basically, the posting of workers, for those of you who are not familiar with the topic, and what is meant with a posted worker, on the slide you can see the definition that we have in our Belgian legislation, which is a very broad one, not necessarily in line with the European vision on a posted worker, because basically the Posted Workers Directive is the result of the, let's say, analysis, or the result of the situation where we have a free movement of services. Companies within the European Union are entitled to provide services on the territory of other member states, and to do that they are entitled to bring along their personnel who would then temporarily cross borders to perform work in another member state. And that's basically the idea behind the Posted Workers Directive. The Belgian legislation, as I said, is a bit broader than that, and actually focuses on employees who usually work on a territory of one or more countries other than Belgium, or who are hired in another country than Belgium. So that's a bit more broad than what was initially intended with the Posting Directive, and it also applies to employees coming from outside the European Union in the Belgian perspective. But that's not what we want to discuss. What we want to discuss is the impacts of the new Posting Directive. So as I mentioned, there are some directives. The old one dates back to 96, and is the result of the fact that indeed there had to be some protection of the labor market, because if companies are allowed to cross borders and to perform services in other member states, then obviously they will do that with their own employees who are protected under the local employment law from their home country, not necessarily the host country. And that might falsify the relationship with other competitors on the market, because let's say the minimum wages in Poland are not the same as the minimum wages in Belgium. And that's the idea behind the Posting Directive that came into force in '96. And it was implemented in Belgian legislation in 2002. In the meantime, there has been a second directive, which you can see on the slide, in 2014. That's basically not a directive that has changed the subject or the content of the first Posting Workers Directive, but was a way to allow member states to enforce the rules of the first working directive in a more efficient way. So that really didn't change anything to the content of the rules that applied. But in 2018, it was then deemed that there was indeed a need for other rules, more specified rules, and those rules we will highlight today. To do that, we need to first address what the first Posting Directive was actually saying. And basically the idea there was that member states were entitled to appoint what we call mandatory minimum protection provisions under their local legislation to ensure that external or foreign service providers had to comply with these rules as of the first day of employment on the territory of that member state. And actually the Posting Directive mentions all of these hardcore provisions in a list in the Posting Directive itself. It regards maximum work permits and minimum rest periods. It regards minimum paid annual holidays, the minimum rates of pay, including overtime rates, the conditions of hiring out of workers, health, safety, and hygiene at work, protective measures with regard to the terms and conditions of employment of pregnant women or women who have recently given birth, or children, and of young people, and the equality of treatment between men and women, and other provisions on non-discrimination. And those are provisions that are deemed to be so important that regardless of what the law is that governs your employment relationship, should be complied with as of the first day of working on the territory of the member state. Now, Belgium has transposed or implemented this directive in its local legislation, as is always required for directives. And there, this choice was made to have a much broader scope than was initially intended in the directive. So basically, Belgian legislation in 2002 said, and you can see that here on the slide, that all obligations or that all provisions of labor, salary and employment conditions of a legal, administrative, or conventional nature that are subject to criminal sanctions should be complied with as of the first day of employment on Belgian territory. And the reasoning behind that was basically, well, it's that important because it is criminally sanctioned. So that was a bit the way in which the Belgian legislator interpreted the directive. It was heavily criticized because it's much broader, as you can see, than the hardcore provisions that were listed in the Posting Directive. So therefore, it was said that, in fact, it's actually infringing the right to free movement of services because Belgium is making it more difficult for foreign companies to deliver or render services on its territory, because you have to comply with basically the entirety of Belgian labor law, because many provisions are indeed criminally sanctioned. Belgium was never really the topic of debate in the European Court of Justice. Luxembourg was, and if you make a comparison between what Luxembourg did at that time and how Belgium interpreted the Posting Directive, I think it's fair to say that if it would have been Belgium standing there in front of the judge, Belgium would have been condemned as well. That has never happened, but it is what it is, and the law has stayed the same. Philip will explain more in detail how the new Posting Directive is coming a bit closer to the Belgian interpretation of the Posting Directive, but that's for the first part. Maybe to skip to the news, or before we skip to the new Posting Directive, another poll question, and it goes as follows. When posting employees to Belgium, the employment relationship, A, must be governed by Belgian law, B, will be subject to mandatory provisions under Belgian law, or C, must remain governed by the law of the home country. We'll leave you the time to answer.
Indeed, that's correct. 93% is correct. So they will be subject to the mandatory provisions under Belgian law. Continue the slides. And then we come to the new Posting Directive, the new directive of 2018. The problem, so to say, with the old Posting Directive was that it was used too much to organize cheap employment in the richer countries. So cheap, so to say, posted workers were sent to the richer countries to reduce costs in these richer countries. The European Commission realized that and has therefore revised the Posting Directive in 2018. These modifications to the Posting Directive are quite substantial. They can be divided in two categories. On the one hand, the extension of the hardcore provisions, and on the other hand, the implementation of an open norm as from 12 months secondment. First, the extension of the hardcore provisions. The initial hardcore provision number C, here you see it. So the minimum rates of pay had to be complied with, has been modified, and instead of the minimum rates of pay, the full remuneration must now be complied with for posted workers. Also, it has been clarified that allowances, which are mixed, this means that it is not clear whether it is a full allowance that qualifies as remuneration, or if the allowance is actually a reimbursement of costs which are linked to the secondment, then in such case, the full allowance is or qualifies as a cost allowance, which means that it does not enter into the comparison whether the remuneration obligation is complied with. And then there are also two new hardcore provisions. The first one is or refers to the conditions of workers' accommodation were provided by the employer to workers away from their regular place of work. So these must also be complied with for posted workers. And the last one, allowances or reimbursement of expenditure to cover travel, board and lodging expenses for workers away from home for professional reasons. The first extension of the hardcore provisions, so the remuneration provision, has not been transposed into Belgian legislation simply because it was already in the existing open norm. The second one has been simply taken over in Belgian legislation. The third one was already in the open norm, and the last one has been taken over in the Belgian legislation, but it has been specified that this new hardcore provision is linked to the place of work in Belgium. What does that mean? Well, it means that if someone has his regular place of work in Ghent and is sent by his Belgian employer to Brussels, and the Belgian employer pays some cost allowance for this trip from Ghent to Brussels, or pays lodging expenses, for instance, on the basis, of course, of national legislation, well, then this allowance must also be paid to a posted worker in the same situation. So in the situation that his regular place of business or work is Ghent, and he is sent to Brussels. But it does, of course, not apply, or these Belgian national provisions which provide such cost allowance must, of course, not be applied to the posting from the country abroad to Belgium. So that's the first major modification of the Posting Directive, which is, however, for Belgium not that important, because the open norm we had in the Act of 5 March 2002 already applied to the full remuneration package and was not limited to the minimum rates of pay. And then the second modification is an open norm as from 12 months postings. So apparently the heavily criticized open Belgian norm, well, the Belgian legislator has apparently been visionary, as now also in the European Posting Directive, an open norm has been installed, not as from the first month, but as from 12 months. So all the applicable terms and conditions of employment, which are mentioned in legislation, regulations, administrative provisions, and or collective agreements, do now apply as from the 12 months, secondment to another country, except for procedures, formalities, and conditions of the conclusion and termination of the employment contract, including non-compete clauses, and also supplementary occupational retirement pension schemes. It is possible to extend this period of 12 months to 18 months upon motivated notification, and there is also an anti-abuse rule. This rule is to avoid that the open norm is avoided by replacing employees, and therefore periods of posting are added together if a posted worker replaces another posted worker to perform the same job at the same place. So you cannot simply avoid the new open norm by replacing a posted employee by another one to do exactly the same job at the same place. Now, what happened with the Belgian Act of 5 March 2002, so which is modified by this Act of 2020? Well, the new open norm has simply been copied in the Belgian Posting Act. Also, the possibility to extend the 12 months period to an 18 months period has been copied, and the anti-abuse rule has been copied. On the slide, you also see the link via which you can apply or request an extension from 12 to 18 months. What does this now mean, or how can we assess the implementation in Belgium? Well, actually, we have now a quite strange situation. We do now have the general open norm, which already existed in Belgium, which was criticized, but is still there. And then next to this already existing open norm, a second open norm, which is slightly different, as the first open norm referred to the criminally sanctioned provisions of Belgian employment law, and the second norm is no longer linked to criminal sanctions, but excludes termination indemnities and supplementary pensions. So we have two open norms which are not identical, which are rather similar, that exist next to each other. The first one for the first period of 12 months and the second one for as from 12 months or, if extended, 18 months. Now, regarding this first part, so the first 12 months, there are still grounds for criticism, as the European directive still provides for a limited list of hardcore provisions, while the Belgian Act still foresees an open norm. But in practice, both have come much more close to each other. Indeed, the major discussions under the old Act or before the Posting Directive, the renewed or the revised Posting Directive referred to or were about remuneration. So has the sufficient remuneration paid to posted workers, and must we therefore comply with the Belgian Act, which foresees that the full remuneration package must be paid, or must we only comply with the Posting Directive, which foresees that only the minimum rates must be paid? Well, this discussion has now ended. The equal pay for equal work is clear and applies throughout Europe. And also the consideration 18 of the directive is quite useful. Indeed, under the old rules, there was quite some debate about how we make the comparison between the remuneration that's paid to the posted worker and the remuneration that must be paid on the basis of the national legislation. Well, this consideration 18 does now help us by providing that the total gross amounts should be compared rather than the individual constituent elements of remuneration. So this means that if you want to know whether a posted worker is paid enough in Belgium, then you first look at what does he receive. You add up everything together, you take the gross amount, and you compare this full gross amount with the amount he should receive under Belgian law. And if there is a balance, if you have to pay something on top, well, then you simply pay an additional allowance. That's the first part. And the second part, well, due to the fact that there was already an open norm for part one, the second part, so the period as from 12 months, is not that different from the first part. In other countries, this will be very different, of course. There are a limited number of provisions, however, that come now on top of what was already due under the open norm for the first 12 months. And these additional provisions are guaranteed pay in case of illness or accident, which are not due for the first 12 months, but which become due as from 12 months. Also, the general obligations of employer and employee, rules on the limitation of liability of the employee, rules regarding birth leave and short leave, commissions for commercial representatives that can be important, and rules on domestic work. But everything together, the modifications or the additional rules that kick in as from 12 months are rather limited. And that brings us to a case study. Maybe before starting with the case study, I have realized that I have, under the Brexit part, not elaborated on the situation of Belgian employees who are sent or who go working in the UK. Maybe 2 words on that. First, the Withdrawal Agreement not only applies to UK employees, but also applies to Belgian employees who were in the UK then at the end of the 31st of at the end of 2020. So also Belgian employees who are working in the UK can in the UK apply for the protected status under the Withdrawal Agreement. Second comment, also the DCA is reciprocal, so also the DCA and consequently the business travel exemptions for employees and self-employed workers apply to Belgian employees who go to the UK. And then third, maybe, if a Belgian employee or independent worker needs a visa in the UK, then this will most likely be on the basis of the new visa regime in the UK, which is the skilled worker visa. And the skilled worker visa is actually based on points. It's a points-based system. To obtain under the new UK rules a visa, you have to gather 70 points in total. If you gather these points, you obtain the visa. And the points, how do you obtain them? Well, they depend on the job offer you receive, how qualified you are, whether or not or you speak English. Also, the remuneration is important, and so on. So that's, in a nutshell, the situation of Belgian employees who are sent or who go working, and independent workers who are working in the UK. But now the case study. So John Europe is a British national who has been working for a British company his entire career. He used to go on business travels throughout Europe regularly, but always dreamt of spending a few years on the European continent. Early 2020, his employer announced the possibility of a temporary project in Belgium. John's wife, who had traveled to Antwerp and Bruges earlier, was immediately fond of the opportunity. John accepted the temporary secondment starting in June 2020, as soon as the COVID travel restrictions were temporarily lifted. This past year has been nothing but wonderful, despite the hardships of the pandemic. John and his wife decided to permanently live in Belgium and have asked John's employer about the feasibility to stay with the company but work remotely from John's new home in Belgium rather than returning to the UK. So we have 2 poll questions on this case study. The first one is as follows: if John's employer were to accept the proposal, which social security formalities should be complied with? A, request an extension of the A1 form. B, file a Limosa declaration. Or C, file a Dimona declaration.
Answers are in, and 42% thinks that an extension of the A1 form should be requested. 25% goes for option B, file a Limosa declaration, and 33% thinks they should file a Dimona declaration. And the last option, or the last answer, is indeed the correct one, because he will switch to a permanent employment in Belgium and will therefore adhere to Belgian social security. Then the second poll question is as follows. Going forward, John's employment will be governed by all employment law provisions under Belgian law. A, with the exception of dismissal rules. B, that are criminally sanctioned, or C, all employment law provisions under Belgian law without exception. Majority got the hang of it, so it's indeed option C, without exception, because he will switch to a permanent employment in Belgium, so he will habitually carry out his work on Belgian territory. This is not a posting scenario any longer, so the full employment law, full Belgian employment law will indeed apply. We are a bit short on time, but we will try to end within the hour. So let's close this webinar off with a few key takeaways. And I think the main ones are as follows. So first of all, continued telework and temporarily seconding employees abroad may have a different angle to it post-Brexit and post-COVID. So that is something that you should keep in mind. And we have a few recommendations for you to consider to avoid unwanted surprises. In terms of secondment, the first one is to make sure to check which formalities, such as a work permit, an M card, a limosa, all of the stuff that Philippe just explained to you, must be complied with prior to the temporary secondment from British nationals to Belgium. And of course, vice versa, if you were to send Belgian nationals to the UK, but that should be assessed then under UK law, of course. And then secondly, take into account all the impact of the new Posting Directive. Say for some exceptions, the entirety of Belgian employment law will indeed apply as of 12 months into the secondment. Those 12 months can be extended to 18 months, as Philippe also explained. With regard to telework, we recommend to assess the employment law and social security impact of continued telework after the pandemic and decide whether these are actually worth taking, or whether the risk is worth taking that chance. If they are acceptable, you can of course allow continued telework, but in that case, we would recommend to draft or amend your current telework policy. And at all times, of course, and that was the case already before the pandemic, but it's useful to know where your employee will actually be working. It's possible that an employee asks to work from their home, for instance, in the Netherlands or wherever in the world, and then switches to working abroad from another exotic country during their telework. That is possible, of course, and that might also have an impact on the applicable employment law and social security legislation. And then lastly, we recommend to implement contractual arrangements such as return to the office obligations that are enforceable towards the employee who enjoys the benefit of teleworking. So that's it. Leaves me to thank you all for your attendance this day. We are very happy you could make it. We hope this was a useful webinar. And if you have any questions, you can find our contact details in the handouts. Thank you very much and see you next time. Bye.